Hi, this is Brian Dolan with the law firm Pepper Hamilton. Each month, Pepper partner Greg Nowak hosts a webinar for West LegalEdcenter, which focuses on issues that are affecting private funds and their managers. You can download a copy of the PowerPoint slides that the presenters went through by visiting Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted. Thank you.
Good afternoon, everyone. This is Greg Nowak from Pepper Hamilton, and happy Thanksgiving in this Tuesday before Thanksgiving. It's a beautiful sunny day in New York. A little chilly, but to be expected in November. And I am joined today for our topic on SEC and FINRA enforcement initiatives by two of my colleagues from Pepper Hamilton. I'm going to ask each of them to please introduce themselves. Jay Dubow.
Good afternoon or good morning, wherever you are for this. My name is Jay Dubow. I'm a partner in Pepper Hamilton's Philadelphia office. I'm in the white-collar and investigations practice group. I began my legal career at the Securities and Exchange Commission's Division of Enforcement in Washington, D.C., initially as a staff attorney and then later as a branch chief back in the 80s. And I've been, since 1989, in private practice, representing individuals and companies and others involved in SEC investigations and securities litigation, other types of securities litigation and internal investigations. I also spent a few years as a general counsel of a public company and saw a lot of these from the other side as well.
And Chris Trueax.
Hello, everyone. My name is Chris Trueax. I am an associate at Pepper Hamilton in the investment funds group. I focus my practice on the representation of investment companies, investment advisors, and boards of directors. In addition to my funds experience, have about 3 years of litigation experience, having previously clerked for a Third Circuit judge in Philadelphia and practiced securities litigation at Deckard LLP before joining Pepper Hamilton.
And again, this is Greg Nowak. I'm a partner in the Financial Services Group and your host for these investment management roundtables that we do every month. The next one that we do in December, the topic will be on cybersecurity as it affects investments, investment management, and investment firms. But today's topic is near and dear to all of our hearts, which is, of course, the SEC enforcement trends. Every year, the SEC does us a favor and prepares a report of what they were looking at during the year. This is a report to Congress. It ties to the fiscal year of the federal government. In January, we will get the Office of Compliance and Inspections focus what they will be looking at during the coming year in 2020. But in fiscal year 2019, the SEC was as active as it's been in the past. And the nice thing about their report is they identify what they think were their highlights. And so as a sort of a way to set the stage, I'm going to go over the 6 highlight cases that the SEC has identified, tell you what happened in all of those, why the Commission thought they were important, and then kick it around with my 2 colleagues to see what lessons can be gleaned from those. So the first one is Facebook. A settled action against Facebook. The Commission alleged that Facebook's risk factor disclosure presented the misuse of user data as a hypothetical when Facebook knew that user data had in fact been misused. Facebook was ordered to pay a $100 million civil penalty. So this was a disclosure case, right, Jay?
Yes, and just as as you're going to go through these cases, I know I find it it's interesting that these 6 cases that you're going to discuss, Greg, that the SEC in its report highlighted all involve companies that most of the people on this call will have heard of, and so it's selective selection on their part of these household names, and in part because they can't be everywhere, and I think that they like to get as big a splash as they can when they bring a case.
It's sort of like the IRS enforcement going after, the big named person.
Sure.
Right?
I mean, a case against Facebook is going to get attention,
right?
Much more so than a case against some unknown company which has a similar, problem. But in this Facebook case, what I think the important message here is, that Facebook's position was, well, they had a risk factor to disclose that this misuse of data, of user data was possible. So they would say, well, we had a risk factor and therefore investors were on notice. But the SEC's position is, well, that's all fine and good, but you actually had that problem, and by just saying a risk factor that something may happen is not the same and fraudulent when it actually has happened.
So this is calling your own man out at first. If you've identified a problem, you can't say, well, this is a possibility, I guess, unless it's really immaterial.
Right. If it's something material, if it's something material or otherwise required to be disclosed because of a particular, SK requirement, for example, that requires it in a 10Q or 10K or an 8K requirement, you can't just say, well, we have a risk factor that says something might happen, if it already has.
If it already has. And so the lesson here is don't try to sugarcoat. If, in fact, something has happened and it's material and it has to be disclosed, don't say, well, there's a possibility it might happen. It actually has happened, and here's how we're mitigating it or dealing with it.
Correct. In addition to the SEC, private actions that plaintiffs' class action lawyers like to bring, often take this very position as well.
All right. In the second matter, Mylan NV. Again, a settled action. The commission alleged that Mylan failed to timely accrue for and disclose its potential liability arising from a Department of Justice investigation relating to the classification of EpiPen, its largest revenue and profit-generating product, as well as making misleading disclosure regarding the risk that government authorities might disagree with that classification. Mylan paid a $30 million penalty. So this is a accounting issue, right? This is a revenue generation and reporting issue.
It's both. It's all falls in all of the above. What happened here? I mean, there's a question about there's an investigation, and do you have an obligation to disclose it? And there's certain rules relating to litigation. Or if there's an action that's likely to be brought, and there's tests for that. If you're challenging the investigation, for example, you think that the government's wrong, you may have a good faith basis to not make a specific disclosure. But what happened here was there were actually the Mylan, in the course of it was actually making proposals to the government to try to settle the case and putting significant money on the table that they were willing to pay as part of a settlement along the way. And when those types of conversations are taking place, then it becomes much more than a theoretical possibility. And from an accounting standpoint, there's a probability that you have to start making disclosures for that and creating a reserve for that.
Well, but hold on a second. I mean, I thought settlement disclosures, or discussions rather, were privileged and could not be disclosed by either party.
Well, the fact of the settlement discussions themselves, but you can still make a reserve if you're involved in settlement discussions and you say offered $10 million to settle the case. You know that you're likely to incur at least $10 million for that, and you can reserve for that. You don't have to say, you don't have to disclose your settlement negotiations or why, but you can make disclosure and reserve for that.
I always tell the story. I'm on the audit letter committee at Pepper, and for those of you who aren't aware of that process, because audit letters are considered to be opinions, they get two-partner review before they get sent out. And basically, there's a treaty between the accountants and the lawyers to make sure that the accountants, of course, want all information. The lawyers have said for years, well, that violates attorney-client privilege, and so we need to have rules about what you can and can't say in response to audit letters. One Friday afternoon, about 5 o'clock, I received an audit letter, and it reflected a $40 million settlement of litigation by a public company. And I said to the partner, we have to make sure this number is correct because it will be immediately on the wire. And they said, no, that's just not going to be the case. Well, I sign off on the letter at around 5:02. I turn on my computer to Bloomberg News, and at 5:22, 20 minutes later, it came across the tape that this particular public company had filed that they had engaged in a $40 million settlement. So these numbers do get reflected very quickly. And, of course, it was after-hours trading, but it did affect the stock price. In fact, the stock went up because everybody was assuming it was going to be a much larger number. But, okay, next case. Fiat Chrysler Automobiles. In a settled action again, the commission found that Fiat Chrysler inflated monthly sales results by paying automobile dealers to report fake vehicle sales and maintaining a cookie jar of actual but unreported sales. In months when the U.S. unit would have a short of certain targets, it dipped into the cookie jar and reported the old sales as if they had just occurred. Fiat Chrysler and its U.S. affiliate were ordered to pay a $40 million penalty. So the lesson here, Jay?
Well, this is an age-old issue. In fact, when I was at the SEC, my very first case involved a company by the name of Oak Industries that had cookie jar reserves. And so, these kind of cases have been going for many years where, reserves and are judgment calls. And so in some cases, and they're subject to some subjectivity, and there have been companies that have tried to, in good times, sort of build up the reserve because, analysts' expectations are at a certain number and we don't need to exceed that, but let's save something if we can because maybe in a future quarter we might need that. And that's, managing earnings. It's improper. And that's what happened here with Fiat Chrysler, and they got caught. And they're so-called caught with their hands in the cookie jar.
But you would think, and again, you've been practicing a long time, Jay, that this type of behavior, people would identify it, realize it, and the accountants would preclude it. How is it possible that this continues?
Well, again, as I said, they're judgments. If people are doing it in a way that is not, creating records, or, disclosing that that's exactly what they're doing, and it just works out that way. And they do it in some kind of, it depends how deep this was. And, sometimes it can be at a lower, sort of lower to medium level, or sometimes it goes all the way to the very top. I know with, my first case, the Oak Industries case, went all the way to the top, and it was the CFO and the CEO, and they were all involved in that process as a way of showing to Wall Street that they were a company that had an steady upward path of earnings and revenues.
All right, Nissan, again, another settled action against Nissan, its former CEO and a former director for false financial disclosures that omitted more than $140 million to be paid to the CEO in retirement. Nissan was ordered to pay a $15 million civil penalty, and the remedies imposed on the former CEO and former director, again, important points here are former CEO and former director, included injunctions, civil penalties, and officer and director bars. So what's the lesson here? If the $140 million is embarrassing and you don't want to disclose it, that whole sense of embarrassment is enough that you should realize you have to disclose?
Yeah, it's not a matter of embarrassment.
Well, why would they not have disclosed it?
So this was a severance type, retirement package, right? So it's not his, and so, they may, or, it's settled, so they may or may not, by the size of the penalty here, it looks like at least the SEC took the position this was done purposefully. And in fact, they took a, officer and director bar against that former CEO. And, looked like he was on the way out, right? And so it's his severance. There was a former director who was looks like was on the inside, who was involved in causing the company to not actually disclose this, and they tried to structure it in a way to avoid that disclosure. But they're both barred, from being an officer or director of a public company, so pretty significant. In addition to, the company was ordered to pay the penalty, but the other folk, the individuals, were paid some penalties, smaller penalties, but they were barred, which was pretty significant.
Yeah, and another instance where the cover-up and or obfuscation were worse than the actual predicate. There's no offense in paying somebody $140 million, right? The offense was in failing
disclosure.
Right. All right, Hertz Global Holdings and Hertz Corp. In a settled action against Hertz, the commission found that Hertz's public filings materially misstated pre-tax income as a result of accounting errors made in a number of business units over multiple reporting periods. Hertz was ordered to pay a $16 million penalty, another accounting misstatement.
Yeah. So, it's amazing, too, in this Sarbanes-Oxley environment where, your internal controls are supposed to be reviewed extensively and signed off on, and the accountants are supposed to be all over this, and you're still seeing these kinds of accounting action. I think, this, again, looks like a straightforward just accounting and disclosure case, and I think it's here. It's settled. There's a $16 million penalty. There's nothing really, I think, unusual or other than the fact it's a name Hertz that we've heard of. But I think the reason it's here is the contrast with the next and last of these 6 cases you're going to talk about.
Yep, PPG Industries. The commission found that PPG failed to properly record various expense accruals and misclassified certain income, which resulted in PPG providing inflated income in its published financial results for 2 years. Based on PPG's extensive cooperation with the commission's investigation, which included self-reporting and remediation, the commission did not impose a monetary penalty.
So I think, you look at that, the PPG case, and that's a message case, and the SC, and they're highlighting here because they're sending the message where, here they had the same, problems that Hertz had as far as, they had accounting and disclosure issues, and
misclassified income, bad
accruals, right.
Yeah.
But look, what happened here in the PPG case was they learned of it, they investigated it, they self-reported it to the SEC before the SEC got wind of it from any other way, and they remediated it, and as a result, the SEC said, okay, we're not going to put a monetary penalty on you because you brought it to us and cooperated extensively.
So let's talk about.
They want to encourage that kind of behavior.
So let's go to the prepared materials, and in particular, Chris, tell us about the statistics on slide number 2. Another busy year for the SEC.
That's right. We have some data from the past 3 years that sort of lays out just raw statistics and shows that the SEC is taking a proactive approach to looking for problems, these types of accounting problems, fraudulent behavior, securities violations. And you can see that if you look at just the first row, independent enforcement actions, the numbers have been significantly trending upward every year. The second row, follow-on administrative proceedings, involves sort of a segue to an enforcement action, a lawsuit, or an administrative proceeding where the SEC may want to follow up and seek some type of, for example, injunctive relief to bar a firm or a person from operating a certain way. The delinquent filings represent steps taken by the SEC to frequently to deregister public companies when they've made delinquent filings. And then you can also see that in the bottom row, not only are the enforcement actions trending upward, but the amount of money the SEC is collecting in terms of penalties and disgorgement is also increasing.
Well, hold on a second there. That's not actual collection. That's what was ordered to be paid. And I thought I recall seeing a statistic somewhere that the actual collections are relatively far from this mark.
Yes.
And that's normally because if you see an enforcement action that says someone is ordered to disgorge however many millions of dollars or to pay a penalty of so many millions of dollars, and they're also barred, right, they can apply for reinstatement. However, one of the conditions of reinstatement is that they paid all monetary penalties, right? So unless they've come up with a couple $1 million, it effectively acts as a lifetime bar. So is there not a Supreme Court case, Jay, that's wending its way, or maybe it's not at the court yet, but it's dealing with disgorgement and whether or not disgorgement is a remedy that is available to the SEC?
Yes. So I think we have that. And why don't we come? We have that in here.
Sure?
Yeah. Why don't we come back to that because we're going to talk about that.
So the statistics do not seem to be showing a material increase in enforcement actions. I guess we had about a 10% increase in independent enforcement, or maybe more like 7%. But the follow-on APIs are relatively flat, and the delinquent filings are relatively the same. Total actions are up. Is there anything in particular that we can point to in those total actions?
Yeah, just a couple points that I'd like to make. If you took this chart and went a year earlier, 2016, in the independent enforcement actions, there'd be a number 548. And the follow-on APs and delinquent filings would be about the same as you see here. So the total actions would be 868. And that was the last full year of the Obama administration. And then when you look at 2017, that was a drop. And everyone was commenting at the time that there was this huge drop because it's, Republican and Trump and therefore, anti-enforcement. And in fact, I've been doing this program with you, Greg, for a few years now. I commented when we looked at that back in 2016 there was the Enforcement Division had a program it was a special program at the time for municipal securities dealers that were and issuers that were involved in certain disclosures that were improper, and you come in and self-report, and we're going to give you a break. And in fact, there were a lot of cases, and that was what caused that 548, that big number. This year, we've got this number 526, which is larger certainly than last year, and much more so than 2017. And a lot of that 526 is comprised of a new program that the SEC had this past year. And we're going to talk about that program in a few minutes, but it's, again, a self-reporting program, and that helped to, push those numbers to a higher level.
And one point I want to make about the data, too, let's not forget that the largest government shutdown in history happened during this sort of SEC fiscal year starting in December 2018, and I think going through late January, it was 35 days that the government wasn't functioning, and enforcement operations were more or less seized or reduced. And so despite that pause during the beginning of the year,
we're almost back to Obama level.
Right.
Exactly.
Of enforcement. Very interesting statistic to keep in mind there. So if we go to the next slide, Chris, the SEC enforcement results.
Yeah, this is just sort of a visual depiction comparing fiscal year 2019 versus the previous year, 2018, showing roughly the categories of enforcement actions being brought. So you can see that actions against investment advisors and investment companies represent the largest enforcement actions this year, followed somewhat closely by securities offerings. Down toward the bottom, the Foreign Corrupt Practices Act, probably less of a SEC domain than the Department of Justice, but you can see how they are pretty actively involved across the board in terms of bad behaviors that can touch on the investment industry.
Yeah.
But any indication why the increase in advisor and investment company?
Yes, because if you look at, again, the next slide, the self-reporting program that we're going to talk about involves the investment advisors, which is why there's a spike.
Okay, so let's talk about the self-reporting program. This is slide number 5.
The SEC periodically has various initiatives, self-reporting, self-disclosure initiatives. The current initiative is referred to as the Share Class Selection Disclosure. It was launched in February 2018, and this is really geared toward investment advisors that manage mutual funds with retail investors. I think all of the dollar figures reflected on this slide were money that was disgorgement / penalties, but disgorgement to go back to retail investors that were misled by inappropriate, misleading disclosures. The program is designed to mutual funds when they offer multiple share classes. Sometimes those share classes have certain fees, in particular 12B1 fees, which is a combination of shareholder servicing fees and distribution fees that are taken from the fund's assets.
Okay, I'm going to stop you there for a second. For the benefit of our audience who may not be imbued with the Investment Company Act of 1940, what exactly is a 12B1 fee? What does 12B1 refer to?
12B1 refers to a rule under the Investment Company Act of 1940 that allows legally investment advisors to charge funds a certain portion. I think it's under FINRA rules. It's capped at 1.25% of the fund's assets to have a portion of that fee be used for marketing efforts on the one hand, and on the other hand, shareholder services, such as answering the phone when you have questions about your fund, various types of services.
These are fees that are charged to the fund itself.
Exactly.
For distribution and marketing expenses.
Exactly. And not all share classes will have those fees. Some will be at cheaper levels. And the important thing is that the investment advisor needs to make shareholders aware.
Is that the advisor or the broker?
I believe it's the advisor in terms of this self-disclosure initiative.
But, well, be careful, because oftentimes the common parlance of someone is an advisor they're really referring to wirehouse or other broker-dealers who are selling the interest in the funds. But in the case of the 12B1 fees, normally it would be a conflict of interest to use fund assets to pay for distribution expenses. The rule allows that as long as you have it approved by the board, by a certain majority, et cetera, and that the fees are used for very specific purposes. So we're charging investors for selling interest in the fund that benefit who? If the purpose is to increase the size of the fund, then that benefits the advisor. If the purpose is to increase the size of the fund in order to reduce expenses and pass those expense savings on to investors, spread costs, fixed costs over a bigger base, then that is a benefit to the investor. And so there's always been this tension in the industry as to what's the purpose of the 12B1 fee, and is it a legitimate charge to charge ongoing investors? And the share class disparity has always been, I might have A, shares that have a front-end sales load, B, shares that have a contingent deferred sales charge, and then C, shares that have a 25 basis point 12B1 fee. Well, if you're going to hold a fund for a very long period of time, the economics of that may be it might be cheaper to pay the front-end sales load and be done with it and not have the 12B1 charge coming out as the fund value increases 25 basis points, also in absolute dollars increases, right? So that's always been the tension, and what the SEC has said is the people who are selling funds have not taken the correct steps to make sure that the people who are buying them understand what they're paying and whether they're paying too much up front. If you trade in and out of funds, then a no-load fund might be a better option. If, on the other hand, if you're buying and holding for a long period of time, a fund that has a modest load up front but no 12B1 or a limited 12B1 might be better. So those are the challenges faced for the person who's actually trying to sell the fund. Go ahead.
And like so much in this area, a lot of this boils down to clear, accurate disclosures about what the options are and which options will come with higher fees or lower fees for whatever types of services are being offered.
So tell us about the self-reporting program.
So this program was one that the staff decided with the commission that they would have people self-report if they had not advised clients about the opportunity to pay a lesser or no fee, and in fact had charged certain clients those 12B1 fees. The idea was you come in, self-report what happened, and now you're in the hands of the SEC, and they said, don't worry, we're going to treat you better than you will otherwise be treated if we have to find you on our own. The program, as the slide notes, began in February 2018. It ended June 12, 2018 as far as reporting. I was at a program recently. Stephanie Avakian is one of the co-directors of the Division of Enforcement, was talking about the program, and she said, that most of these types of programs, most people didn't report to the very end, and they were concerned, was anyone going to show up to the party that they had? And the staff, she said the staff was thinking that others were probably talking amongst themselves, what should we do? And they ended up getting a large number of firms to report. As you can see on slide 5, as of March, there were 125 million collected. That's disgorgement from 79 advisors. So they got the money back in these fees, and if they self-reported, then they did not have to pay any kind of civil penalty on top of that. So if you go to page 6, then there was another more recent, again, people had reported, and now the SEC is kind of working their way through these to get one. You have to figure out how much to disgorge, and did they disclose everything they were supposed to disclose as well, making sure that everything was, that was disclosed is correct. So in addition, there was another 17 investment advisors that were charged. 16, what's interesting about this, 16 self-reported. So that raised the total number of 95 firms, $135 million of fines, because they paid collectively $10 million of, not fines, but disgorgement, but no civil penalties. But then the one firm that they found so far that did not self-report, they had $1 million of disgorgement, and that firm had to pay a $300,000 civil penalty in order to settle. So if you look at that was a 30% civil penalty. If you apply that across, the $135 million, the other firms, that would be a pretty significant number in fines that they were able to save.
Simply by self-reporting. And what's the normal advice that we give people faced with these facts? Consider self-reporting?
Yeah, I think you have to consider it. This issue comes up a lot. We talked about before. Remember the PPG case at the outset. If you learn of an issue and a problem that the SEC would be interested in, there's always this sort of dilemma. Do you self-report at the SEC, or do you sit back and think, well, are they going to find it? And there's lots of ways the SEC can find things. They can find it because maybe your auditors learn it and they report it, or these days with whistleblowers, we'll talk about in a little bit, whistleblowers, and they get bounties for bringing these things to the SEC's attention. There's a lot of incentive for others out there to bring these things to the government's attention. So you run, if you don't, self-report, you run the risk that the government's going to find it, and you're going to get, not get the benefit of the cooperation. There's always that, well, maybe they will never find it kind of a thing. And it just depends on, it's very facts and circumstances. We get involved in these and we can, advise how bad is it. You want to try to remediate it first if you can. So you can go to the government if you're going to self-report and say, here, we got this problem. We investigated it fully. Here's our report. And here's the remediation and the steps we took. And, it's all tied in a bow, and, either leave us alone or just slap us on the wrist, and let us go on.
So now we get to the Liu case. And, one of the questions that have always, been in my mind is, at what point does disgorgement become so burdensome that is in effect like a criminal sanction or criminal penalty? And does the SEC even have that authority under the current statutory framework? And the Supreme Court granted certiorari to review the term, to review this term, whether the SEC may obtain disgorgement from a court as an equitable relief for securities law violations. So, Jay, what do you think?
Well, so this is a very, very interesting case. So this case comes as a result of a prior case,
Kokesh, right?
Kokesh case. So just a little history here. You know, the SEC, the securities statutes provide, say what things are illegal or not. There's nowhere in there with regard to the ability to get disgorgement in federal court. That was all judge made under a judge's equitable powers. You know, SEC brings an action and they seek an injunction from future violations, which is equitable, and they started seeking back to the Texas Gulf Sulfur case. Most of these come up a lot in insider trading cases to disgorge what you earn. Now, the government has taken disgorgement further. So if somebody, for example, cooked the books so that their income was high, companies' earnings were higher, and if they had a bonus tied to that false income, they may seek disgorgement of that bonus. So there's all different ways that they can seek disgorgement. But the easiest way to think of it is an insider trading case. It's either, if you made profits or avoided losses, that's a very easy concept. And then the SEC and Congress provided them back in 1980 with the ability to get penalties, civil money penalties in these cases, because it used to be, well, if I got caught, insider trading, all I'd have to do is give the money back. And then they would say, okay, well, now you're going to get up to a treble penalty on top of it, so there's some real risk. But there was nothing codified about disgorgement. So now you have this. In the context of statute of limitations, there's a 5-year statute of limitations for general statutations for and something that's deemed a penalty. And so the civil money penalties have been deemed to have an applicable 5-year statute of limitations from when the event took place. And there was a challenge in the Kokesh case to say, well, wait a minute, disgorgement can be punitive as well. And in fact, the Supreme Court in the Kokesh case said yes, disgorgement is punitive and subject to a 5-year statute of limitations. There was a footnote in the Kokesh case that says we're not here today to comment and decide whether disgorgement's allowed at all. And so once that footnote was in, a lot of practitioners who had cases in front of the SEC would start raising it. Well, you can't get disgorgement. You can't, you're not entitled to it. So this Lube case worked its way up from the Ninth Circuit and challenging the ability to get disgorgement at all. And the Supreme Court took cert, so they're certainly interested in it. The thinking is that it's likely that the court may decide that disgorgement is not available. Having said that, and that would be certainly a win for defendants and people on the other side. That Congress right now, there's a couple of bills working their way through Congress to not only to statutorily have disgorgement, but to also put a longer statute of limitations in. There's one bill in the House that actually proposes a 14-year statute of limitations, which happens to be the length of time that Kokesh was involved in the particular scheme. There's another one that has a 10-year statute of limitations that's being proposed. So there's thought that even if the Supreme Court were to abolish disgorgement as a remedy, that Congress will likely put that back and put it back with some more teeth with a longer statute of limitations.
Do we think the Constitution would enable Congress to pass such legislation?
Yes. Yes. There's another related area that again flows from Kokesh, which is whether an injunction itself, just as a beta law injunction, which is a typical remedy in an SEC case that says, if you violated a particular provision of federal securities laws, we're going to enjoin you from violating that again in the future. If you do, you could be subject to contempt. There have been some courts that have held that an injunction is punitive and therefore subject to the 5-year statute of limitations. There was one in the District of New Jersey, the Gentili case. The Third Circuit reversed and said, no, it's not. An injunction is not punitive. But what the Third Circuit said was, but when it goes back to the district court for reconsideration and consistent with this order, we don't want you to rubber stamp the SEC's asking for an injunction. You, district court, have an obligation to look at the contours of the injunction to make sure it's appropriate. Because typically the SEC just says, you have an injunction permanently, forever, against any kind of violation, say, of 10b-5. And the suggestion there was that the courts should be, drafting, approving, I should say, injunctions that are perhaps in some cases more narrowly tailored.
So an interesting court session coming up with the SEC, front and center again with the Supreme Court.
Correct. Let's argue this will be in
January, right?
Yeah.
Yeah. Very interesting developments. All right, so one of the places where the SEC gets the grist for the mill, if you will, is the whistleblower program. Chris, obviously continues to be an ongoing SEC priority. Tell us some of the statistics coming out of the whistleblower program with the SEC. And of course, now that we have the whistleblower program in the State Department front and center in the congressional hearings, obviously everybody's talking about what are these whistleblowers, how do they work?
Well, the SEC's whistleblower program, which has not been around for that long, just going back to 2012, provides pretty strong financial incentives to people who work at companies, investment advisors, to report concerns about potential or actual securities violations. So since 2012, the SEC has awarded more than $384 million just to 64 individual whistleblowers for reporting violations that the SEC was then able to take action on. The program also provides, in addition to the financial incentives, provides anti-retaliation protections so that whistleblowers are protected from their companies retaliating against them for reporting violations. And the SEC, under that power, can actually bring enforcement actions against an employer that tries to retaliate. One other provision of, typically what happens is the whistleblowers will report the concerns directly to the SEC, and they can do so anonymously. But the program also has a provision where a person can internally, inside their company, report a concern about a violation. The company can start an internal investigation, but as long as the whistleblower also reports those concerns to the SEC within 120 days of reporting it inside the company, they can still receive an award. And we don't have it on the slide, but the SEC uses sort of a sliding scale metrics to determine the amount of the award, based on the size of the actual violation, how proactive the whistleblower was in reporting it. Those can increase the award, but if also the whistleblower has some culpability, they may still get an award, but it could be reduced. So it's a fairly complex program.
Do we have any statistics on how many of these, how often an internal report finds its way into the whistleblower program?
I don't think there's statistics, but there's quite a bit. There's many. They've had hundreds of what they call very good tips. Now, sometimes a whistleblower will come and it's already an ongoing investigation, so they won't get an award, but they will help contribute to the SEC's investigation. The other thing is there's a lot of whistleblowers who go to the government, and then as Chris said that there's this anti-retaliation protection. So now they're protected from retaliation, and the SEC takes that very seriously. Even if it turns out that they were wrong, even if there wasn't any violation, if they had a good faith belief that there was, then they're protected.
And the SEC's enforcement annual report notes that there were thousands of complaints received in 2019. The SEC is very, very keen on this program, and they note that they are taking steps to streamline the program, streamline the intake of complaints, and that they expect 2020 will be an even bigger year in terms of whistleblower.
Yeah, I think that this program, again, if you look at the first bullet, there's only 64 whistleblowers since 2012 who have been paid anything. But this omnipresence effect really has, companies concerned, and it goes back to, do we self-report things? Now that people have a financial incentive to go to the government, it does change the equation when you're advising a company about whether or not you should self-report or take certain action. The fact that there's this potential whistleblower out there who might be, even if you don't have one on the horizon, but you just have to assume that there could be one, that has to factor in.
So a company has an internal complaint, whistleblower complaint, internally. They do an investigation. They take remedial action, but they choose not to report. The whistleblower is still free to go forward, right, and report to the government.
Correct. And absolutely can do so. There were some. There was actually when the whistleblower rules were proposed. There was a lot of, as you can imagine, back and forth between companies and the SEC in terms of trying to encourage. How do you want to encourage whistleblowers to go internally first? And it was set up in a way to actually, some of the rules are set in a way that do try to encourage internal whistleblowing first, so that it allows a company to investigate and perhaps remediate before it gets, out of hand. And so that's sort of built into the system. The other thing that's important to keep in mind in this area, in addition to just the general anti-retaliation provisions, that there are SEC rules that say you cannot have a contractual provision that would prevent someone from wanting to go to the government and be a whistleblower. So and this comes up in the following context quite a bit. You have someone who has some issues with, maybe it doesn't rise maybe to even a full whistleblower, but it's just a difficult employee, and you want to get rid of that person, and you work out a deal and you pay them a big severance, and you want to get a release from them, and then if you draft that agreement in a way that says that they cannot go to the government as well, that would be in violation of the SEC rules, and it's counterintuitive, because you'll say, well, look, I'm paying this person a lot of money to go away, but they still have the right to still go to the government. So you have to be careful, because that itself is an SEC violation.
The gift that keeps on giving. So some highlights from the recent fund exams from the Office of Compliance Inspections and Enforcement. What are we seeing there, Chris?
This particular risk alert that was just published by the office, popularly known as OC, focused on issues and problems with internal compliance procedures and disclosures, noting that it's really important to ensure that disclosures accurately represent pricing methods, sales literature. Also, finding there were some deficiencies in providing enough information to fund boards of directors to make sure that the fund is able to exercise its oversight role in terms of services, of fees. So really this boils down to this particular risk alert, the importance of maintaining internal compliance procedures, making sure that the relevant decision makers internally have enough information to manage those programs and procedures, and making sure that the funds are providing adequate shareholder disclosure about material terms.
Pricing methods, sales literature, all the normal things that you would expect in a well-run business that you've paid some attention to. All right, so let's...
Sure. I just want to comment on that. I mean, I think, when you look at these, these are the things that OC is focusing on, and many of these often then end up as enforcement actions because they're not getting adequate responses. And I think one of the issues that I've seen, and many times is people have policy. Everyone's got a policy, but a lot of these policies that funds have, advisors have, they're so many times off the shelf, and they're not tailored to that particular entity, or they're not reviewed and updated for the business that they're doing today. It's like, well, we've got this policy, but that doesn't do you any good if it's not, again, tailored to your business and the way you run your business, and has to be updated because sometimes your business might change a little bit. And so that's very important, because just having that policy isn't going to protect you.
And that's actually a really good point. Merely policies on the shelf or policies that are taken from a consulting firm that are not tailored to the specific needs of the business are very important. Before I came to Pepper, I was EVP at an asset management firm, and our building was in a converted paper mill. And whenever we would have a heavy wind or rain, the sand that was used to sandblast the ceiling and get rid of all the mold from this 200-year-old building would creak out of between the boards and fall on our desks. And the SEC came in for a routine exam, and they said, well, we'd like to see your compliance manual. And I took it off of my bookcase and blew the dust off of it. And the guy's like, oh, you got to be kidding me. This is classic, right? Because that's their complaint. That you never open your compliance manual and you blow the dust off before you give it to them. But we, just pointed to the ceiling, and luckily, it would rain while they were inside, the dust while they were there. So we've got about 10 minutes, so we're going to do a lightning round of a bunch of cases in the materials. First one, SEC versus Chen.
Yeah, this is related to the SEC's, that they're touting a recent ability through software and data analytics to address problems that they couldn't have done a few years ago. They have apparently proprietary software that lets them analyze big data, voluminous data, trading data, and also communications metadata. So this case here is an example where the SEC was able to pick up on activity by 18 foreign traders who were creating a bunch of shell entities, shell broker-dealers, to artificially manipulate the prices of more than 3,000 listed U.S.-listed securities by using these entities and communicating with each other to artificially drive up and down the prices and benefit from a type of arbitrage process. The SEC was able to target these individuals through complex software formulas, IP address recognition, and again, isolate them and sort of pick up on this pattern.
So, lesson from this case?
I think it just the real lesson is the SEC's got some guns and ammo in its arsenal they never had before. When I was on staff, everything was manual. This is the ability to do something like this is without someone on the inside would be impossible.
Well, 3,000 securities, listed securities, and 18 different traders moving those stocks.
Yeah.
Just assembling that data alone is a massive task.
Exactly.
And you could not do that without artificial intelligence. Okay, Robert, Advisor Act material in the statement. Chris?
Yeah, Robert is probably more interesting for the lessons and the holding of this case, as the D.C. Circuit case, than in the facts. But essentially, the Robert Group, an independent investment advisor based in Houston, Texas, had in 2004 entered into a revenue sharing agreement with Fidelity, which it used as a platform for retail investors to access its funds. It had an arrangement with Fidelity where Fidelity would pay it a percentage every time an investor signed up for one of the Robert Group's funds through the Fidelity platform. That arrangement was never publicly disclosed. In 2011, Fidelity put pressure on Robert, said, you got to make this public. Robert did, but not with the specificity the SEC wanted. Robert, in their Form ADV, said they may enter into revenue sharing arrangements with third-party entities, third-party platforms.
And Jay, the takeaway from that?
Well, what happened here, though, is actually from those of us who practice in this area find very interesting, because there was a long-standing view by the SEC that if you intentionally committed an act, that meant it was willful, and therefore it violated Section 207, which requires, again, willful conduct. 206 is a negligence-based anti-fraud provision, and so here the finding by the D.C. court said no. Here that there wasn't a willful effort by the firm to not disclose, fail to make the disclosure, and that this really changed the nature of the practice in this area, because this was something that the SEC, again, had for many, many
years, since Onsover in 2000.
That the SEC's position, willful meant just intentionally committing the act would constitute the violation, and the court said no. The text says that the commission had to find, based on substantial evidence, that at least one of the principals of the firm subjectively intended to omit the material information from the Form ADV to prove Section 207.
Okay, BBT Securities.
BBT Securities is an example that's relevant to entities, especially who are duly registered as investment advisors and broker-dealers. I think entities that, like BBT Securities, can offer or advertise being able to offer sort of a package deal. You can get good investment management services and take advantage of the connection with the internal broker-dealer to get cheaper costs, better services. At least that's what BB&T represented to the public and to their investors. Turns out they were providing market services at best, arguably worse services than their peers, but charging 4.5 times the amount. So a disclosure problem, essentially lies.
Jay?
Yeah, this was a settled case. Again, most cases are settled. The vast majority of cases are settled for various reasons. It might be because they're wrong. It might be because they just don't want to fight with the SEC, or you have different reasons. But so most of these are settled. The one before that was not. That's why we had an opinion. But this, they paid $5 million of disgorgement, which that included actually prejudgment interest, and then they had to pay a civil penalty on top of that of $500,000.
Deer Park Road.
Deer Park Road involves a breakdown and a failure of compliance policies and procedures to make sure that in this case, the hedge fund manager was valuing securities in accordance with generally accepted accounting principles. This fund primarily invested in distressed securities, but the SEC was concerned that there were not appropriate safeguards to make sure that the fund's traders were valuing. They looked to the SEC that the fund's traders were devaluing securities, artificially over time upping the value in order to sort of make a profit when needed. Kind of reminds me of the cookie jar analogy earlier. And also the valuation committee, it was led by the chief investment officer and his relatives. So again, some concerns about proper oversight and SEC found irregularities in pricing. But and you can see the settlement amounts at the bottom, the $5 million penalty and the $250,000. But interestingly, there's no documentation of actual improper valuations here. I think this is a lesson for the risk of that happening.
So no actual improper valuations, and this was just the risk that there may have been improper valuations.
Exactly.
Because of the conflicts and because of
improper
procedures
that weren't tightly linked to the...
Right. But this was settled, but there also, what the SEC did note that the that there was notes in the margins, right, that they actually approved certain of these inadequate valuations, but then there was a note that said mark up gradually. So that was, again, the cookie jar sort of, knowing that it was undervalued, mark it up gradually.
Well, that's always been one of the issues on smoothing of performance results. And again, when the tax laws changed way back when in 1984 and 86 with respect to reporting of discount and premium on instruments, How do you account for these things when there can be wide fluctuations? Can you smooth it out? The cookie jar approach. SBB research.
Okay, well, this has sort of a funny backstory. This was one of the most successful hedge funds in the country in terms of its performance record. Founded in 2010 by a college student from his dorm room who was really looking to make a big reputation for himself. Got a lot of family money, then became an SEC registered investment advisor and tried to solicit outside money. Turns out the successful performance record was artificial because he actually used a complex mathematical formula to alter the valuation methodology that he used to price the securities in his portfolio, primarily investing in structured notes. He also took steps to hide this behavior from auditors, from the investors, and the SEC. For example, when an outside auditor found that these irregularities were happening, rather than the manager did credit his investors a portion of the overcharged fees, but took steps to not explain what was really happening.
Jay? Yeah, I'm going to say the valuation cases, and there's a few of them in the group that we have. They involve assets that are sometimes difficult to value. They might be mortgage-backed securities or other distressed assets or things. They're not, stocks and bonds that have a easily valuation on the market.
And then finally, the Gonzalez case.
Yeah, kind of a quid pro quo situation involving a broker-dealer, the CEO of the broker-dealer, and an employee, Frank Danucci. Frank Danucci sort of perpetuated an arrangement with one of the broker-dealer AOC's customers, Premium Point Investments, which is an investment advisor. So Premium Point had an arrangement where they were dictating prices that they wanted Frank Danucci to value securities in exchange for steering trades over to AOC and Frank Danucci. So Frank Danucci was in a separate lawsuit, personally pled guilty to criminal allegations, including fraud. But this case here involves sort of a failure of the company and the CEO to provide proper oversight, proper supervision of its employees.
Yeah, well, what's interesting about this case is yesterday a Manhattan judge sentenced Premium Point Investments' former CEO 50 months in prison for directing a scheme to overinflate the hedge fund's assets.
Wow, 50 months. The SEC has also been very active in cyber-related misconduct, in particular ICOs and digital assets. Most notable there was the fact that the SEC fined and went after so-called celebrities who were touting digital assets without disclosing that they were being paid to do so. You can't get celebrity endorsements for your product without saying, hey, this is a paid solicitor. The SEC has proposed changes to the solicitation rule, which there will be more on those as well, and also on the derivative accounting for funds and other investments. Those proposals came out yesterday, and of course, stay tuned and have future programs on all those topics. Thank you for your attention. As always, if you have any questions, please feel free to contact Jay Dubow, Chris Trueax, or myself, Greg Nowak. Have a great day and happy Thanksgiving.